Welcome to Buy Sell Basics Part 3. I'm Erin Tenner. I'm a partner in Duffy, LLP, and I've been handling buy sells for 30 years, but I cannot figure out how to get my screen to scroll down now, and I have a feeling it's because I've got this link open. There we go. Haven't done a lot of webinars. So this is the first in a 5-webinar, or this is the third in a 5-webinar series. The first webinar was about the 3 different types of buy-sell agreements: asset transfer agreements, stock transfer agreements, and owner's agreements, and when each is used. Part 2 discussed the basics of one of those, asset purchase and sale agreements. And if you want to view either of those, you can go to our website at www.grayduffylaw.com. This webinar is on stock purchase agreements. The last 2 webinars in the series will be on how to make sure you don't lose your investment if you are buying a partial interest, and it'll be about shareholder agreements. And the final webinar will be on real property purchase agreements and how they fit in with the different types of buy-sells. So I want to start with a funny story. Before going out of town on business, a man who had just bought a brand new Rolls-Royce was faced with a dilemma. He drove his car to a downtown New York City bank and went in to ask for an immediate loan of $5,000. The loan officer was quite taken aback, but the man was well-dressed and appeared to be wealthy, so he agreed to give him the money, provided the man could give him some collateral. "You can hold on to my new car," said the man, and handed over the keys to his new Rolls-Royce. The loan officer promptly had the car driven into the bank's underground parking for safekeeping and gave him $5,000. 2 weeks later, the man returned and asked to settle up his loan and get his car back. The loan officer checked the records and told him that'll be $5,000 in principal and $15.40 in interest. The man wrote a check, thanked the loan officer, and asked that the car be brought around. While waiting, the loan officer said, "You're clearly wealthy. Why in the world did you need to borrow $5,000? "I didn't," the man smiled. "I needed a parking spot. Where else could I securely park my Rolls-Royce in Manhattan for 2 weeks and pay only $15.40? So when you're negotiating a buy-sell, it's no different than when you're running a business. You have to think outside the box, kind of like this gentleman did when he needed a parking spot. Or better yet, get rid of the box altogether. I've handled hundreds of buy-sell agreements in my 30-year career. Yes, that's a picture of me. Creativity is key to getting deals done. Usually a buyer will want to buy assets, but sometimes a stock sale will make a deal possible that wouldn't have otherwise been possible, or just might make it more attractive to the seller, and I'll explain why in this webinar. I'm going to use the word stock in this webinar to define an ownership interest in any kind of a business, whether it's a corporation, a membership interest in a limited liability company, or a partnership interest in a partnership. It's just easier. So stock sale and purchase agreement is different from an asset sale and purchase agreement in that it transfers all or a portion of an entire business, lock, stock, and barrel, rather than just assets. When you're buying the stock of a business, unlike an asset purchase, you buy all the cash, all the receivables, all the payables, as well as the assets, and you're going to get all the liabilities and obligations. You can't pick and choose. That means that due diligence is more important than ever in a stock purchase agreement. So the liabilities and obligations that you'll purchase will include all employment obligations, the lease for the building, which may or may not be at fair market rent, might not be an arm's length deal, contract obligations, whether for equipment leases, maintenance contracts, employment contracts, whatever kind of contracts may exist, tax liability, environmental liability, litigation, and the list goes on and on. The purchase agreement needs to protect the buyer, if you're buying, from things that should be disclosed but aren't, and from things that can't be discovered through due diligence, as well as things that are discovered. So I'm going to talk about 4 different areas with respect to stock purchase agreements. First, I'll talk about when you might want to consider purchasing capital stock instead of assets and why. Second, I'll talk about the exposure that you're buying when you buy capital stock and the due diligence that's required and why it's so important. Third, I'll talk about some of the tax issues that come up with stock purchases. And finally, I'll wrap it up with the pros and cons of buying stock. Why would anyone want to purchase capital stock when they could avoid all liability of the seller by buying just assets? Well, there are a number of reasons. First, the stock purchase may be more affordable for a buyer because the seller's paying only capital gains tax on the sale, and the buyer is buying all liabilities. The purchase price will often be lower for a stock purchase than for an asset purchase, in part because the seller is willing to sell at a lower price, and in part because there are just a lot of liabilities being purchased. Sometimes the seller will have net operating loss carryover credits that can make a deal more attractive for a buyer. Sometimes the seller can't sell assets without triggering unvested or deferred liability. For example, underfunded pension plan liability will vest on sale of assets. Depreciation has to be recaptured on sale of assets. These can be large expenses for a seller, but in a stock sale, they don't have to be paid by the seller. They remain a company liability, so the buyer gets them. And often they can be reduced or eliminated over time. A stock purchase agreement is also going to be a lot simpler than an asset purchase agreement. Instead of listing all the assets that are being purchased, it simply provides for transfer of the stock. It'll have warranties and representations and conditions, just like an asset purchase agreement, but probably a lot more extensive. But other provisions are going to be unnecessary. For example, there's not going to be a need for a new lease or assignment of an existing lease. There's not going to be any need for provisions regarding termination of employees or parsing out how records will be handled, because they all just stay with the corporation, and only the stock of the corporation is transferred. And the seller doesn't have to wind down the business after closing, which is a huge benefit for any seller. And then if a buyer is buying just a partial interest in a business, then the buyer is going to have to buy stock. I've had many people ask me whether or not a buyer can buy just some of the assets and get an interest in the business, and the answer is no. I talked more about that in my first webinar. So if you want to hear more about it, you can go back and listen to that. So where is the exposure in buying stock? The most expensive area of possible exposure will vary depending on the circumstances. People often ask me if I have a form that they can look at for a buy-sell. It doesn't really work that way. Each deal is so different. For example, if the seller is a C corporation, there could be unpaid income tax liability and possibly penalties and interest. An S corporation would not have income tax liability because it's a pass-through entity, so the shareholders pay the income tax, not the corporation, unless it lost its S election. But the warranties and representations would have to be about the S election, not about income tax liability. Same for an LLC. It won't pay corporate tax unless it's elected to be treated as a C corporation for tax purposes or as a corporation for tax purposes. So C corporation can also convert to an S corporation. And if that was the case, then there could be built-in gain, which will have other ramifications. So you can see how there are many different considerations arising just out of the type of entity. And there are multiple considerations like this on many topics when drafting any agreement. So whether it's C corporation or an S corporation or a limited liability company, there are going to be some corporate taxes, even though they might not be income taxes. For example, sales, employment, and franchise tax liability can be very substantial for a buyer if not handled properly in a stock purchase agreement. And I talked more about how to handle those in the last webinar. You can listen to it. It's pretty much the same for stock purchase agreements. So one of the first things to look at when buying stock is the stock certificates that are being transferred, because they'll disclose any restrictions on transfer and any rights of third parties or consents that are required prior to transfer. Restrictions can be things like rights of first refusal, options held by others to buy the stock, requirements that notice be given, or permission that consent be obtained prior to transfer. If there are no restrictions on the face of the certificate, at least in some cases, the buyer can take the stock free of the restriction. But the seller could still have liability for violating the restriction and any damages to the person who it benefited. If the restriction is written on the face of the stock certificate, then the buyer could actually lose their interest in the stock if they violate the restriction. So it's important to know what's on there. Another area that can be very expensive is environmental liability. I've seen costs in the mid six-figure range on more than one occasion. And they can go a lot higher than that. How high will depend on the nature of the contamination and whether it hit groundwater. I've only seen contamination, or I've only been involved in a case where the contamination hit groundwater once. And in that case, the district attorney was going after the landowner for on criminal charges. And the tenant was the one who had caused the contamination. I was representing the landowner in that case, and fortunately in the lease, it provided that the tenant was responsible for all of the maintenance at the dealership for the clarifier, which is the reason that the water had gone into a nearby stream with contamination in it and contaminated the stream. The clarifier wasn't working properly. And because the tenant hadn't properly maintained it as it was required to do under the lease, and because the tenant was responsible for all environmental liability and maintenance, we were able to get the DA focused on the tenant, which was no small task. So really the only way to prevent criminal liability, because you can't be indemnified for it, is to make sure that things are being done properly. So you want to do a thorough environmental inspection if you're buying land. And as a seller, if you own land and you're selling stock and you're going to keep the land, you better make sure your lease puts the responsibility for violation of laws and maintenance with respect to any environmental matters on the tenant. And you want to do that before you enter into a stock purchase agreement, because once the agreement is signed, nothing's going to change. And you have all the control. It makes it a lot easier because you're not negotiating with anybody. You can just change your lease prior to agreeing to sell stock. So what happens if you're in a situation where you're buying land and the buyer tells you that there was an underground gasoline tank, but it was removed, but you can't find any records of it having been removed? We had that happen once. And that's not uncommon, because back in the 80s, prior to the late 80s, there really wasn't any oversight for removal of underground gasoline tanks. So you don't want to rely on somebody's memory of whether or not a gasoline tank was removed. In that case, we had to have the ground x-rayed, and we found nothing. But is that even enough? You know, it could have been in a different location. Sometimes people don't remember properly. Gasoline and oil aren't the only potential issues. Gasoline's a real issue because it seeps through the soil quickly and can get into groundwater. But there are a whole list of other regulated contaminants, including pesticides, solvents, and paints. So as part of any environmental investigation, public records, including photographs, will be viewed going back 50 years to see how the property was used, and the property will also be examined to see if there are things like car batteries laying around, discolored soil, or other evidence that there's been dumping at the property. So whether you're a tenant or an owner, you need to know what's there. If an issue is detected, it needs to be addressed prior to closing. You don't want to wait till after closing. And sometimes it can be just soil vapors that, you know, contain contamination, not even the soil. So there are a lot of issues there. Employment practices is another area that can result in expensive exposure depending on how well the seller has managed employees, and its responsibility as an employer to make sure proper records were kept, that employees were properly trained, properly paid, allowed rest periods, hired and fired appropriately, and that employees and customers have been treated with respect. Yes, an employer can even have liability for customers who are abusive if they don't deal with it. So poor management habits can be costly to a business and can result in company liability for wrongdoing, because management level employee conduct is attributed to the entity. This includes liability for torts and fraud. when you buy stock, you're buying that exposure. An auto dealer could lose a franchise because the owner didn't know a manager was committing fraud or that a manager committed perjury. How could that happen, you might ask? Well, let me give you an example. Say a dealer tells his service manager not to offer warranty work that has not been requested to customers. The service manager thinks this is a lost opportunity, so he sets up a business to handle the warranty work that the dealership doesn't do or doesn't want to do. He sends customers to his business, which does sublet warranty work as a preventative measure, even when there's no recall. Since it doesn't cost anything, the customers agree to have the work done. According to the manager, everyone benefits, right? Wrong. The warranty spike is noticed by the factory, and a warranty audit is triggered. The service manager lies and says he has no ownership interest in the business that is getting all the warranty work because he senses something's wrong and he's going to get in trouble. The owner asks him to sign a declaration under oath stating he has no ownership interest in the business that's getting all the warranty work before he prepares to contest the several $100,000 chargeback of warranty work from the factory. The manufacturer does a little digging after the service manager signs the declaration and deposes the service manager, who proceeds to again lie to be consistent with his declaration. The factory, in doing its digging, finds out that he really does own an interest in the business. It's not that hard to figure out. Because they now have him lying in his deposition, and they can basically say he committed fraud and he committed perjury, and now they have grounds to terminate the dealership franchise because he was a manager, and the manager's fraud and perjury is attributable to the dealership, and one of the grounds for termination under any dealer sales and service agreement is fraud. So it didn't matter that the dealer didn't know about it. The manager fraud is attributed to the company. So it's important to know what's going on at a dealership if you're buying that liability. And even if the manufacturer doesn't terminate the dealer, you can bet they're going to use that kind of information to hand it off to somebody else that they want to have that franchise, because that happens all the time. So due diligence entails looking into all these things: financials, employment practices, environmental liability, litigation, books and records, vendor contracts, customer contracts, leases, public records, reflecting real property liens, tax liens, security interests, intellectual property, corporate records, looking at whether the seller has LIFO on its books, whether assets that should be written down on the books were, tax returns, whether receivables are collectible or should be discounted, and whether the entity has any built-in gain, each of which could end up costing the buyer later on and will affect the buyer, what the buyer is willing to pay for the business. So some exposure, you'll be happy to know, can be mitigated with insurance policies, which can be purchased at closing. Insurance can be purchased, for example, for employment liability and environmental liability, and it was the perfect solution in that case where we couldn't find the tank that the owner remembered had been there and there were no records of it. So known environmental contamination will not be covered if it's found, but if you're worried there might be something and you haven't been able to find anything, it will cover. Also, employment liability insurance will cover a lot of different things. Wage and hour claims are rarely covered by insurance, but there are some companies that do cover wage and hour, and so it's great to find one of those if you're buying stock in a corporation with all the class actions that are out there on wage and hour claims. And another way to reduce exposure in a partial purchase is to have the seller form a subsidiary, drop the assets into it, and then sell the stock in the subsidiary. That's a little bit more complicated. So indemnity agreements are another way to protect the buyer from all of these potential liabilities. A promissory note with a right of offset for some of the purchase price is another option. Holdbacks, personal guarantees, these are all ways that a buyer can be protected in addition to insurance. However, an indemnity agreement is only as good as the indemnitor, and sometimes people hide their money. I told a story in a prior webinar about a guy who transferred all of his assets to his wife to avoid creditors. This is known as fraud, by the way, so I don't recommend it. not only for that reason, but also because in this case, his wife ran off with everything. Now, who knows? Maybe he met up with her later on, but we'll never know. Knowing what contracts have been signed and having warranties and representations that all have been disclosed and reading them to make sure they're reasonable and benefit the business is important. And also making sure there are no breaches is important. Nothing can be assumed when buying stock. Warranties and representations are going to be required to cover all these things, and then due diligence is done to check and make sure they're true to the extent they can be verified. If some turn out not to be true, the buyer is going to need to have the right to back out of the deal or renegotiate it. And if too many are not correct, then the buyer is probably going to want to back out of the deal because you don't want to get in bed with somebody who can't be trusted. Corporate maintenance also has to be reviewed. A buyer can end up with personal liability for corporate obligations as a result of a seller's failure to properly maintain or manage the corporation, because it can lead to alter ego liability, which means the corporate veil can be pierced and owners can be held personally liable for corporate obligations. And then it's also really important to know what assets are owned. Some things you might want to exclude. I was talking to a client once and explaining to him that everything gets transferred when you sell stock and asking him what assets were owned in the corporation. And he told me one of the assets was some land. And I said, are you intending to transfer that? He said, no. Well, he hadn't even thought of the possibility that that would be transferred with the transfer of the stock. So if the seller agrees to sell stock of a corporation or a limited liability company, everything it owns is going to be transferred. Seller who isn't thinking about what assets are owned could inadvertently sell things like classic cars, sports memorabilia, art, or land. So let's talk a little about tax consequences. How assets are accounted for and handled can affect the tax consequences of a stock transfer. For example, it could be very costly to a seller to sell stock without first withdrawing cash equal to its AAA account balance, assuming it's got the cash in the corporation to do that. So as corporations and limited liability company owners pay taxes on income, even if it's not distributed to them, because they're pass-through entities. And that income on which tax has already been paid goes into what's called a AAA account. When the income is later distributed, it's distributed without paying an additional tax. If it stays in the corporation, the seller is going to likely be getting more money for the corporation because there's additional cash in there and paying capital gains tax on it. And if there is no cash in the corporation, there are creative ways to still get cash out. And sometimes it can be millions of dollars in, the AAA account. So it's an important issue. A buyer may also be able to save some money by allocating some of the purchase price to personal goodwill, even in a stock transfer. This will allow the buyer to amortize the goodwill over 15 years, which you wouldn't be able to do on just the stock itself. You can't amortize the purchase price for stock. Another way to save taxes, if you believe tax rates are going down, is to have the buyer pay some of the purchase price over time on a note. That way the seller only pays taxes as the money is received. And the same is true if money is put into an escrow and, as a holdback. Then as it's received by the buyer will pay taxes on it because there's that contingency that they might not receive it. And one of the pros of buying stock is that the tax liability to the seller will be lower for a number of reasons, including capital gains tax rather than ordinary income tax, no tax on recaptured depreciation or on LIFO recapture, and no sales tax on fixed assets, all of which will be paid by the seller after closing of an asset purchase. Now, some of it might be collected back from the buyer, like sales tax. So far we've talked about how buying stock can make a transaction more feasible that might not otherwise be feasible by making it more affordable for the buyer or seller. We talked about how liabilities are all purchased with the entity that's being purchased, making due diligence a lot more important, but there are several other pros and cons. For example, transferring stock creates a very smooth transfer because nothing needs to change right away. buyer may choose to make changes over time, but they don't have to. As a result, there are many things that aren't needed, like a WARN Act notice, for example, which would hold up a closing in an asset purchase for 60 days for any seller who has over 100 employees, or even 75 in California under the California WARN Act. A seller will not have to pay any creditors or wind down its business or dissolve its corporation or LLC because it's all being transferred. It won't have to close bank accounts, terminate permits. It won't have to assign contracts or negotiate new ones. This is because the lessee is the entity that's being transferred. Nevertheless, consents may be required. Typically, landlord, lender, and factory consents will be required prior to a change of ownership. So what's the downside of buying stock? A buyer can't pick and choose what liabilities it'll buy. It's going to get all of them. The buyer is going to find out over time what liabilities the entity has that were not discovered during due diligence. And the buyer will need protections after closing for things discovered after closing. Although the buyer won't technically have successor liability because there's no successor to the business, it continues to be owned and operated by the same entity that always owned and operated it. There's only a successor owner of the stock, which is the buyer. Buying stock or a limited liability entity insulates the buyer from any of the entity liability as long as the entity was maintained properly. But, of course, entity liability is going to reduce profitability for a buyer, so it's still important. So in summary, buying or selling stock is going to make the transaction simpler and less expensive up front, but it could be more costly for a buyer over time, since all the liabilities will be fully revealed over time. Thorough due diligence can reduce the risk, as can a holdback, indemnity agreement, guarantee, or paying some of the purchase price over time with a right of offset. If you don't have the right of offset, paying it over time doesn't do you much good because you don't have an automatic right to offset money owed against any promissory notes. Having a note payable over time also provides some tax benefits. In a partial transfer, another possibility may be setting up a subsidiary, dropping the assets into it, and having the buyer buy just an interest in that subsidiary so that the buyer isn't buying all the liability. There are still other issues that come up in that regard because what do you do with all of the liabilities and what happens? You're still going to need a shareholders agreement, which I'll talk about in the next webinar, but what happens if that parent entity ends up being lost to creditors? Then you're partners with the creditor, unless you have a right to buy it, buy out the stock, but then you're buying a mess. So there's a downside to even doing that. But all of those things would be addressed in a shareholders agreement, which again we'll talk about in the next webinar. So the best thing you can do whenever you're buying or selling stock or assets or any business is make sure that the person you're dealing with has good character. Because if the person has no integrity, you're better off not doing the deal at all, unless you can get it cheap enough to make up for the nightmare it's going to cause you in the end. And you're going to know this probably by checking the person's reputation prior to even getting into the deal. But certainly if you haven't figured it out before you do the due diligence, you'll figure it out in doing due diligence. Thank you for attending this webinar. I hope you found it helpful. If you have any questions, you can email me or call me at 818-907-4071 or 4000. That's our main number, and I'll be happy to answer your questions.